Hi, I'm Phil Ashey from the American Anglican Council and the ACNA Governance Task Force. It's that time of the year again when we begin to look at amendments to our Constitution and canons in preparation for Provincial Council in June at the Cove. So this year, the Governance Task Force had fewer canons to actually amend, but more issues around the succession and election of bishops. So what I'm going to do is go through the proposed changes and explain why we're making those changes and the background. And I'll go from Title I canons, nothing in Title II, Title III canons, and Title IV canons. So here we go. We're starting with Title I, Canon 5 of Dioceses. And what we're doing is we're adding some minimum requirements for dioceses. You know, the minimum requirements right now for a diocese are 12 congregations with an average Sunday morning attendance of at least 50 and a collective attendance of 1,000. But we're adding this. A diocese shall demonstrate that there is sufficient financial support for the office of the bishop and shall provide financial support to the province in the spirit of Title I, Canon 9, which is the 10-10-10 model. You know, the individual gives 10% to the church gives 10% to the diocese gives 10% to the province. In exceptional cases, the provincial council may modify these requirements for application for diocesan status provided in this canon on a case-by-case basis. Well, why are we doing this? And the background is every year the executive committee is supposed to do a review of the dioceses and see if they're sustainable. And that's always been a cause of confusion because how do you tell whether a diocese is sustainable? This change in the canon is to establish a more numerical basis for understanding sustainability. Not whether or not you have a compelling vision for mission or how your clergy are doing. All those things are important, believe me. But what we're saying is for purposes of an annual review of sustainability based on the provincial reports, we're simply saying what we believe every diocese can and is demonstrating that is sustainable, namely these numerical minimums in terms of average Sunday morning attendance, the financial capacity to support a bishop, and financial support for the province. That makes it easier for the executive committee to do every year its sustainability review and to identify those dioceses that may already be struggling well before they come to the College of Bishops for permission to elect a new bishop upon the retirement of their bishop. This sustainability review is a necessary prerequisite for the College of Bishops to view before it permits and gives consent to the process for electing a new bishop. So this makes the process much easier and much clearer for the executive committee to do every year. And under Section 7, we spell it out that every year the executive committee shall review the annual diocesan reports with the objective of determining whether each diocese meets the requirements for a diocese as provided in Section 1 of this canon. So if they fall below the numerical minimums, if they don't have the financial capacity to support the office of a bishop, if they're not giving 10%, those are all reasons the executive committee can pick up the phone and call the diocese and say, hey, we'd like to open a dialogue and see how can we strengthen you. And ideally that happens then well before the pressure on for the need for consent to an election for a bishop. The second canonical change we were asked to look at was the possibility of removing the option of selection by the College of Bishops of one among a number of nominees for episcopal election by a diocese as provided by Article 10 and Title 3, Canon 8, Section 3. So currently, Article 10 reads that the College of Bishops shall have authority to consent to authority in the election of bishops of the province, which may be consent to an election from a diocese or the actual choice and consent from among two or more nominees put forward by a diocese. And the College of Bishops, questioned whether they should have this authority because, if a diocese doesn't know who to elect, who are the College of Bishops to know who to elect? And in fact, back in, I think it was 2019, we actually approved an amendment to the election for a special bishop and removed the option of consent and just said, look, we're not going to have multiple candidates. The College of Bishops is responsible for electing a bishop or special bishop. They can decide who that is. Not as clear with the diocese. And we know at least one diocese that may be having an election in the future that would appreciate us retaining that option for the college to actually choose one or between two or more candidates that the diocese forwards to the college for election. So we're going to put that off. We're going to take it back to the college for further discussion, and if they think it's appropriate, we'll bring it back in 2024 when we'll have both a provincial assembly and a provincial council, because this needs to pass. It would require an amendment of our constitution, which we've never done, and that will require a supermajority in the assembly as well. The next proposed amendment is in Title III, Canon 8 of Bishops, Section 4, concerning the election of a bishop. Consent or choice by the College of Bishops shall be based upon the canons for holy orders as provided in Title III, Canon 2, Sections 4 through 6, and Canon 8. So that's new. We're adding a particular basis for the bishops to give their consent. And we have the remainder of the canon as it is, the affirmative votes of 2/3 of the membership, and then we add this, which consent shall normally be given by the next regular meeting of the College of Bishops and in writing to the originating body, which means you don't have to wait a whole year for a College of Bishops meeting. If they meet by Zoom, they can give that consent. Now, why are we changing this? Why are we adding specific reference to Title III, Canon 2, Sections 4 through 6, and Canon 8? Well, the College of Bishops have been wrestling over this whole issue of what is the nature of their consent once a bishop's been elected by a diocese. And those who champion the value of subsidiarity say, look, as long as the diocese has followed its own procedures, College of Bishops should simply kind of rubber stamp and formalize that election. And if that were the case, then we'd be back to the days in the Episcopal Church when that's the only question we asked. We don't want to go to that extreme. The other extreme is, well, the College of Bishops can do a complete review de novo, and if they don't like the person, they can just send that person back. Well, we don't want that either. So how do we balance these competing values? And what the college really wants is something to hang that consent on, to make it meaningful, because you're electing a bishop not just to the diocese, but for the whole church. And there are three things as we consider a bishop for the whole church: the bishop's character, his competence, and his doctrinal knowledge and faithfulness. And by giving these two canonical references, which include everything in Title III that we look at for deacons and priests, but adds that particular section about divorce and remarriage to make sure that our candidates are not divorced and remarried except under the provisions that allow this for anyone in holy orders as provided under the biblical exceptions. And Canon 8, which is Title III, Canon 8, which has to do with the requirements for a bishop. So this way the consent for the College of Bishops, once someone has been elected by a diocese and comes up to them, has a more rational, measurable basis. And that lends itself to a more meaningful consent to electing someone who is a bishop, not just of the diocese, but of the whole church. Our next series of amendments are in Title IV on ecclesial discipline. And there's a lengthy set of amendments to our Title IV canons that have to do with inhibitions. I'm not going to go through every one, but I'm going to explain as many as I possibly can. They're going to be in the report that you receive along with this video report, and some of them will highlight. Here's the problem. What happens when a bishop behaves badly? A report comes to the archbishop, or maybe a report of the archbishop behaving badly comes to the dean of the province. And typically this accusation of bad behavior requires a response and some kind of an investigation. But we want to make sure, if it's the archbishop dealing with a bishop, or if it's the dean having to be concerned about the archbishop, we need to make sure that whatever bad behavior is happening can be prevented from continuing. And that means there are times when the archbishop will need to issue a godly admonition against a bishop, to ask him to stop doing things or stop meeting in certain places or whatever, or even an inhibition from exercising certain duties of his episcopal ministry. Currently, the archbishop does not have that explicit authority under the canons. So the following amendments that I'm going to point out to you in Title IV address that lack and provide checks and balances to make sure that we are not giving some extra metropolitical authority unchecked to the archbishop to admonish and to inhibit bishops right and left, but provides also a process of appeal and review by senior bishops, and I'll explain this in a minute. So, the first is in Title IV, Canon 2, of charges against bishops, presbyters, or deacons, and we're adding to that the following title of charges against and godly admonitions to bishops, presbyters, or deacons. All the same offenses, and then under Section 2 concerning godly admonition, we're adding this section. A godly admonition is a written directive from a bishop to a member of the clergy, but then we're adding Section B, new Section B, the archbishop to a bishop, or C, the dean of the province to the archbishop. No admonition shall be issued until the bishop, archbishop, or dean of the province, or such person to whom authority has been validly delegated under these canons, shall have met personally with the one receiving the admonition, because we now need to include bishops or even the archbishop. And the issues have been clearly and fairly discussed. And then a few grammatical changes. Now we add this. In the case of an admonition to a bishop, the archbishop must first consult with a panel of the 5 senior active diocesan members of the College of Bishops by date of consecration, exclusive of any bishop involved in the admonition, before issuing an admonition. So this means that the archbishop can't just write out an admonition and fire it off to a bishop. He's now got to call up bishops and say, I have this problem, I need your help. Please, here are the facts that have been given to me. Would you approve of this admonition? Now, in the case of an admonition to the archbishop, the dean of the province, and remember, the dean of the province is the second in command, so this is the logical person to whom this much originated. The dean of the province must first consult a panel of 5 senior active diocesan members of the college by date of consecration, exclusive of any bishop involved in the admonition, that would be the archbishop, before issuing an admonition. So again, you've got checks and balances there. The next is Title IV, Canon 5 of Courts, Membership, and Procedures. And we added, just to be sure, under Section 2 concerning courts for the trial of a bishop, paragraph 1, the court of the trial of the bishop of this church, including the archbishop. And then under paragraph 3, the senior bishop at date of consecration shall be the president of the court. The archbishop, or in case of a proceeding against the archbishop, the dean of the province shall also appoint a legal advisor to the court. So again, checks and balances. Under Title IV, Canon 9 of inhibitions, concerning inhibitions, and then we struck of a presbyter or deacon because now inhibitions generally apply to bishops as well. An inhibition is now defined as a temporary suspension of the archbishop, a bishop, a presbyter, or a deacon from the exercise of ministry in whole or in part when one having authority under these canons believes, upon reasonable grounds, that the accused has engaged in conduct upon which an accused may be presented, and or the bishop believes that it is in the best interest of the accusers, the church, and or the accused to do so, etc., etc. And then we add this: an inhibition shall be in writing, signed by one having authority under these canons, or one to whom authority has been validly delegated under these canons. Now, under Section 2, concerning inhibition of a presbyter or deacon, we simply say a bishop may temporarily inhibit a presbyter or deacon under this canon. We don't have to recite all the language that went before. And with advice and consent of the standing committee or its equivalent, any inhibition of a presbyter or deacon may be extended, etc., etc. Under Section 3, concerning inhibition of a bishop, we strike the language that's currently there and then add all of the language, which I'm not going to read, about how the archbishop may temporarily inhibit a bishop under this canon. The process he has to observe, the consent he has to have from other bishops, the application by a bishop who's been inhibited upon a showing of good cause to appeal, modify, or revoke the temporary inhibition within 30 days of the application. And then the same process concerning the inhibition of the archbishop, how that is done, and how the archbishop himself may also appeal and seek either a modification or revocation of the temporary inhibition within 30 days of such application. Now again, the rationale for all these extensive amendments in Title IV, we believe it provides the needed authority for the archbishop to act in a reasonable and speedy manner upon receipt of an accusation against a bishop. And we believe these draft amendments preserve the checks and balances in our constitutional and conciliar governance by requiring the archbishop to consult with a panel of senior bishops by date of consecration before issuing an inhibition, or for that matter, an admonition. And the provisions for appeal from an inhibition likewise preserve the checks and balances inherent in our constitutional and conciliar form of governance. All right, so the next amendment is going to be to Title IV, Canon 10, which is notification of all diocesan clergy by the sentencing bishop. And currently, when a sentence is delivered to the archbishop's office, there's no mention of the sentencing bishop notifying the clergy in the diocese that a fellow presbyter or deacon has been sentenced under Title IV for either voluntary submission to the discipline of the church or has been convicted by a court for the trial of a presbyter or a deacon for some offense under Title IV, Canon 2. So there's kind of this cone of silence, as one of our members pointed out. You know, the clergy in the diocese don't know what's happened to a fellow presbyter or deacon, they might call them up on the phone and say, hey, could you come and take my church while I'm on vacation? And unwittingly violate a canon themselves by having a deacon or presbyter serving who shouldn't be serving. So we're adding to Title IV, Canon 10, the following sentence, that after the bishop or archbishop pronounces sentence as provided, this new sentence, the sentencing bishop shall also notify all of the clergy in the diocese in which the deacon or presbyter has been sentenced. And then we modify the language to this. Such required notice shall be limited to the offense under Title IV, Canon 2, for which the member of the clergy has been presented, tried, and convicted, or voluntarily submitted to the discipline of the church, and the sentence imposed under Title IV, Canon 8. And we believe, again, this addresses the needs for disclosure to diocesan clergy for the good order of the church. The notice is limited as provided in the sentencing canon, and so we believe this is a good method. Now, there are a couple of other things that we needed to attend to, and I'll just mention these things in passing. Should we add a provincial canon defining membership in good standing within a congregation? That's going to be an important definition that we have moving forward, particularly for purposes of defense in claims seeking to limit our religious freedom in hiring, in performing rituals and marriages within the church, etc. Congregations and dioceses are all over the map on this, so we've appointed a task force to begin to solicit information about what membership in good standing constitutes in different dioceses and congregations, and see if we can develop a model diocesan canon, because we believe this is ultimately something that each diocese needs to decide. With regards to the courts of our province, all three of our provincial courts have not yet elected a presiding officer, nor have they adopted rules of procedure for each court, which are required by canon. So our esteemed Vice Chancellor, Jeff Garrity, drafted a set of proposed rules of court for our provincial courts. And hopefully by the time you watch this video, all three of our provincial courts will have met, will have elected presiding officers, and adopted, at least in some provisional form, these rules of court. We also want them to be model rules for your diocesan trial courts. And if you haven't already adopted rules of court for your diocesan trial courts, please take a look at these. We will send these to you, make these available also, and we commend them to you as something you might want to consider. Look them over, see if you might want to amend your existing rules of court, and if you don't have rules of court for your diocesan trial court yet, I'd commend these to you. And then finally, we are working with the nominations committee of the executive committee to help provide position descriptions and nominees for our provincial courts. So those are just some of the things your governance task force has done and is doing for you. This first round of comments we invite you to make to all these changes on or before April 15th. And if you have any questions or comments or amendments that you'd like to offer to what we've done, please send those to me directly, to my email, pashy@americananglican.org. It's going to appear right now and for the next minute or so on your screen, so you can take that down. What I will do is pass these on to the various subgroups that are working on our Title I, Title III, and Title IV canons, and they will consider those and get back to you and let you know. Our goal is by May to have a second report with the final draft of our canons for you to respond to by the end of May, so that we can then send that on to the delegates for Provincial Council 2020, which will be meeting at the Billy Graham Training Center at the Cove in Asheville, North Carolina. And they will then approve these subject to final approval by Provincial Assembly 2024. And they will be provisionally in effect. So I commend these to you. Thank you for your attention. God bless you. And please feel free to send your comments to me directly, and we will make sure they are passed on. God bless you.